Ashley, you may call the next case, please.
Nashville Church of Christ, Inc. as successor in interest to Central Church of Christ versus Amy Grant Gill and Andrew M. Burton as administrators of the estate of A.M. Burton et al.
Good afternoon, Your Honors, and may it please the Court. My name is Tanya Austin, here with co-counsel Joshua Denton on behalf of Appellant Nashville Church of Christ, successor in interest to Central Church of Christ, and I would like to reserve 4 minutes for rebuttal.
4 minutes. All right, you may proceed.
Thank you, Your Honor. Your Honor, this matter is before the Court on our appeal from the decision of the Davidson County Chancery Court on the reciprocal claims for declaratory judgment in Count 1 of NCC's complaint and Count 1 of the counterclaim filed by the represented defendants or the Burton appellees here. We're here today to ask the Court to reverse the Chancery Court's decision to grant partial summary judgment in favor of the Burton appellees, which found that the conditional limitations in a 1925 deed for the NCC's property is still, the conditional limitations are still valid despite a release of those conditions in 1970. NCC contends that the trial court erred in not finding that the 1970 release extinguished the conditional limitations such that the Burton parties have no interest in the property whatsoever, whether contingent, vested, future, or otherwise. So just quick background for context. The 1925 deed included conditional limitations on the use of the property that, if violated, purported to cause the title to that property to vest in, quote, the estate of the said A.M. Burton. The parties all agree that the 1925 deed created an unvested executory interest in a third party, the estate of the said A.M. Burton. Now, when Mr. Burton died in 1966, the conditional limitations had not been violated and the executory interest was still unvested. So when his will was administered, his estate was administered, the future interest was not mentioned separately in his will, but he had a residuary clause wherein he left all rest, residue, and remainder of his property to his wife, Lily Burton. So NCC contends that based on that residuary clause, upon Mr. Burton's death, the unvested executory interest passed to Lily Burton, making her the holder of the interest at that point. Then in 1970, believing herself to be the holder of that future interest, she executed a document called Instrument Removing Restrictions, which we've called in the briefs the 1970 release. On its face, the 1970 release had the express purpose of clearing title to the real estate. So these facts are not in dispute. So the ultimate question before the trial court on summary judgment was really the impact of this 1970 release. Are the conditional limitations in the 1925 deed still valid, and specifically in light of the 1970 release? So to answer these questions, the trial court had to first determine whether executory interests like this one are alienable, such that it could pass through inheritance, and then second, whether Lily Burton had the authority and did release the conditional limitations, which she indisputably intended to do with the document in 1970. So in answering those questions, the trial court correctly found under Tennessee law that future interests are alienable where the initial taker is ascertained. And in this context, ascertained just means there's no contingency as to who will take. There's just a contingency as to whether a certain event will ever take place. NCC does not challenge that conclusion on appeal. But the trial court then found that the estate of the said A.M. Burton was not an ascertained taker, which the court found made it impossible for it to pass through inheritance. So building on that finding, the trial court found that the unvested executory interest, quote, remained with the estate of A.M. Burton, unquote, leaving Miss Burton without the authority to release the conditional limitations with the document in 1970. These are the findings that NCC does challenge from Chancellor Martin's opinion, both of which really come down to the proper interpretation of the meaning of the phrase, the estate of the said A.M. Burton, and whether that is an ascertainable taker.
What authority do you have, what Tennessee authority do you have for your interpretation of the ascertainable person here?
Well, that's the main issue, Your Honor, is that there's no known Tennessee authority where this particular issue has been addressed, where the question of the estate of a then living person, what does that mean in a conveyance like this of a future interest? We've not been able to locate any case addressing that particular issue. The Burton Appellees haven't cited to any either, and I don't believe Chancellor Martin had any in the order that we've appealed. That said, we looked to other courts all over the country trying to find some guidance on this, and we found two that addressed almost the exact issue that we have here, and that is the Supreme Court for South Carolina and the Kentucky Court of Appeals, in both fairly old cases that were looking at issues similar to ours from a time close in time to when the 1925 deed was executed. So the first one is Cannon v. Ballinger, and that is from 1952, the South Carolina Supreme Court. And in that case, the issue is the construction of a specific conveyance in a will executed before 1912, which granted a future interest in property to Emma Cannon's estate. Now, at the time of that, the will was executed, and upon the death of the testator, Emma Cannon was alive. And she was also alive at the time that future interest vested, and she went into possession of the additional property when it vested. It wasn't until after her death, when her heirs were involved in partition actions and selling off property, that the conveyance was even challenged. So in looking at that challenge, the Cannon Court determined that the word estate was used rather loosely to signify that upon vesting, the property should be given to Emma Cannon, the individual. There was no presumption by the court there that estate had to mean probate estate. They looked at all the meanings and found that the idea that she would need to, that it would need to be an estate after her death was just not tenable. And getting there, the court in Cannon relied on the 1929 opinion of the Kentucky Court of Appeals, so written pretty close in time to our 1925 deed, and that's King v. Wirtz. In that case, the court looked at a very similar issue of the estate of a then living person and interpreted it again to mean the person themselves. So, for example, the estate of Tanya Austin would just mean Tanya Austin. And in getting to that conclusion, the King Court expressly rejected the argument by the opposing party in that case, which was estate of the living person should mean heirs of the living person. The court said, no, it can't be that, because that could result in a situation where if the conditions were violated or the future interest vested while the person at issue is still alive, that would result in a situation with title just floating around in the sky with no one able to legally claim it until the death of the person at issue. And interestingly, that's the exact argument that the Burton Appellees make here, is that estate of A.M. Burton means heirs of the said A.M. Burton. And it's just not tenable under Tennessee law, and they take it another step to mean that we have to wait until the conditional limitations are violated to even look around and see who the heirs are of A.M. Burton before we can be done with the analysis. And it's, this is a man who died almost 60 years ago at this point. So again, this interpretation is just not tenable. And under that interpretation, for example, if the conditional limitations from the 1925 deed had been violated in 1930, we would have had a situation where title to the property is just in limbo for 30 plus years until the death of A.M. Burton, where we could have identified who his heirs would be. And that is not possible under Tennessee law, where it's well settled that title to real property always needs a conceptual resting place. It can't just float and be in abeyance. So because there's no controlling authority in Tennessee, and we believe this is a first impression, at least in reported case law with our precise issue, we asked the court to follow Cannon and King and find that the estate of the said A.M. Burton was intended by the grantors in the 1925 deed to be synonymous with A.M. Burton, the individual, and thus a conveyance to an ascertained person. Again, this is the only interpretation that guarantees that fee simple title to the property would never be floating around in the air with no one able to legally claim it. So from there, having determined that the initial taker is ascertainable, the question then becomes whether the unvested executory interest did pass through inheritance to Lily Burton. And that's an easy question that should be answered in the affirmative, because the executory interest was indisputably not vested at the time of A.M. Burton's death. Upon his death, It passed through his probate estate to his beneficiary, Lily Burton, making her the holder of the executory interest. So from there, the only question is whether the 1970 release was effective to eliminate those conditional limitations. And this one is an even easier question because the analysis is not challenged by the Burton appellees. Tennessee law is clear that the holder of an unvested executory interest can release and convey that interest if she so chooses, and we've outlined all of that in our brief, the opening brief, pages 22 through 28. And the Burton appellees don't refute this point. If NCC's interpretation of the 1925 deed is correct, they don't refute that Lily Burton's 1970 release would be effective to release those conditional limitations. Their challenge is just that it never passed through inheritance and she was never the holder of the interest in the first place. So in summary, because the initial taker under the 1925 deed was an ascertained person, A.M. Burton the individual, he was able to and did pass the unvested executory interest to his wife, Lily Burton, upon his death, making her the holder of the executory interest. From there, in 1970, she had the authority to and did successfully eliminate the conditional limitations with the 1970 release. So we asked the court to reverse the trial court and instead find that the 1970 release was effective to completely eliminate the conditional limitations in the 1925 deed.
Did the trial court make any finding as to the effect of that release, or did it just stop short of analyzing anything about the release because it found that she did not have the requisite authority to sign that release?
I'm almost out of time, but may I go ahead and
Yes.
answer your question? It was exactly that, Your Honor. The court went through the analysis of everything leading up to that, but once she found that the estate of A.M. Burton was not an ascertained taker, the analysis really stopped. She said that the interest stayed with, quote, the estate of A.M. Burton, and almost by default, Lily Burton would have had no ability to release something that she was not currently the holder of. So there was no deep dive analysis on the effectiveness of the release or of any of the authority that we provided showing that under Tennessee law, the holder of a future interest can release that back to the holder of the estate prior.
Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. My name is John Belcher. Elizabeth Sykes and I, and also our partner Bill Lassiter, I've counseled with the firm now. He's 85 years old. He's part of this case. He wanted to be here. He's not well enough to be here today, but I wanted to mention his name as well. We represent Amy Grant Gill and Dr. Andrew M. Burton as co-administrators of the estate of A.M. Burton, and we also represent a majority of the other defendants in this case who are family members of the Burton family, and we've just been collectively referring to that group as the Burton defendants. The trial court identified, and the parties agree, that there are only two issues in this case: whether the conditional limitation from 1925 is valid, and if so, whether it's been violated. And today we're only here regarding issue number one. Issue number two has not been addressed yet. Issue number one is what summary judgment was entered on, and that's what we're here today on. And it's specifically our position that the conditional limitation is still valid, that Lily Burton's 1970 release did not release anything at all because she had nothing to release, and the case law is clear that an unvested remote executory interest can't be released, alienated, sold, or transferred. To the court's question a moment ago, what the trial court said about that specifically, quoting from the record, page 477 and 478, the unvested executory interest remained with the estate of A.M. Burton and not an individual or ascertainable person until such time the conditional limitation was violated, if at all. Thus, Lily Burton was without authorization to release the conditional limitation, and the 1970 release was ineffective to eliminate the conditional limitation. So And then we'll also address, even if the 1970 release was effective, there was a 2018 quitclaim deed that reinstated the conditional limitation. So for those reasons, accordingly, the Burton defendants respectfully contend the trial court's ruling should be affirmed in all respects. I'll kind of skip over the facts, but I do want to point out a couple of things in the facts. The case here diagrams A to B and then to C. So this is not a possibility of reverter. This is not going back to the grantor. The grantor in 1925 was the Timothy family. They granted it to the church, and if that was ever violated, it would go to a third party, the estate of A.M. Burton. And that's what the 25 deed says. It's a very long provision. It has, the conditional limitation has two parts. One about how that building is used, and if it's ever not used in that way, it will go back to the estate of A.M. Burton, a third party. And then the second, it says, in the event it's ever transferred, then it will, those restrictions will be included in the transfer. The 1970 release was executed by Lily Burton in her individual capacity, not on behalf of any estate. But again, it's our position respectfully that she had nothing to release because this was an unvested interest and pursuant to the case law could not be released. So the issue in this case comes down essentially to which line of cases governs this dispute. The line that we've relied on, Yarborough, Whitaker, Standard Knitting, we contend is a perfect fit. They're from the Tennessee Supreme Court. They've never been overturned. They're all good law. They stretch from 1925 to 1967, and they all diagram the same way, A to B, and if B violates, then to C. They all address the rule against perpetuities, and they all stand for the proposition that an interest, an unvested executory interest, is not alienable, can't be transferred, can't be released. And I believe the court had a question about Tennessee law on this issue of ascertainability, and we contend that there is a case. It's on point. We cited it at the trial court, and we cited it in our brief, and we've cited it in every brief ever filed, and that's the Whitaker case. And in the Whitaker case, Whitaker versus House, 1963, the Tennessee Supreme Court looked at a situation where A, the grantor, transferred to the state of Tennessee and said, you can have this land as long as you use it as an armory. And if you ever don't use it as an armory, then it goes to the city of Columbia. Well, the city of Columbia then leased it to an identified fourth person, D. So we had a situation where every single category was ascertained. We knew the grantor, we knew the grantee, the state, we knew the contingent executory interest holder, the city of Columbia, and we knew who they released it to, D, who would be analogous to Lily Burton here. And what the Supreme Court said is, all that goes away. That's not enforceable. It violated the rule against perpetuities. It could not be transferred, it could not be alienated, it could not be leased to D. And it wiped away all of that.
Mr. Belcher, let me interrupt you for a minute. All of the cases that you've cited that you're relying on, you just listed, are before the statutory, I believe it was in 1994, the statute, and as far as we no longer follow the common law rule against perpetuities now. So do you have any authority that follows that same line of reasoning? Because as I understand it from your briefs and the Whitaker case, I think turned on remoteness of the interest. And do you have any cases that are post-1994, post-statute, that still recognize or follow the remoteness of the interest argument? Because it seems to me that most all of those cases are analyzing, well, all those cases definitely that you listed there, but the cases where we've seen that look at remoteness of the interest are all having to do with the common law rule against perpetuities, which is not applicable to this.
And that's the key to our argument, Your Honor, and I'm glad the court asked that. Our argument is that at the time of 1970, when Lily Burton executed this release, she had nothing to release because that interest was subject to the common law rule against perpetuities, because it was remote, it was unvested, it was not ascertainable, and it wouldn't vest within a life in being plus 21 years. Therefore, as the trial court correctly concluded, she had nothing to release. The release she signed was meaningless, just as she could not have sold that or conveyed that or done anything with it. Now, so if this case had been decided in 1970, it may very well have gone a different way. But in 1994, the Uniform Statutory Rule Against Perpetuities is passed, and what it says is important in two respects. One, it specifically says, we've cited in our brief, it looks prospectively forward, and it also looks backward. And two, it does not apply to non-donative transfers. So what that 1994 statute does is it saves this interest in the same way that the court in 2003 in White versus Hayes, that's a case we've cited, and in that case, the trial court was asked to construe the will of Dr. Hillary Key, who, the will was from 1912. The trial court concluded the will violated the rule against perpetuities because the interest in question would not vest within a life and being plus 21 years. The Court of Appeals in 2003 said, well, we've got to go back now under the new statute and reconsider the 1912 instrument in light of the new rule. And so it's that new TUSRAP, Tennessee Uniform Statutory Rule Against Perpetuities, that saves this 1925 executory interest because it specifically says it's retrospective in application. And when we look back from the vantage point of 2024 back to 1925, applying the new statute, that interest is effective because it's a non-donative transfer. It was for $36,000 of consideration. That's not in dispute. It's not disputed in the briefs. And it's saved by, and the trial court correctly focused on this issue. And so the rule against perpetuities, the common law that's not in effect anymore, the reason it was so important, we talked about it so much in our brief, is it becomes very difficult to reconcile these two lines of cases. We put a chart in our brief, and the chart talked about 3 different cases, all from the Supreme Court. One in 1900, Bruce, which the appellant relies on. 1925, Yarborough, which we rely on. 1926, Frank, which the appellant relies on. These cases aren't citing one another, yet they're not overruling one another. There are 2 parallel lines of authority. One that says, Yarborough, Whitaker, Standard Knitting, that if it's an unvested, remote executory interest, can't be transferred, alienated, sold, released, can't do anything with it because it hasn't vested. The other line, the Bruce line, says interests that aren't remote, that would not violate the common law rule against perpetuities, could be released. And that's the distinction. Every one of those cases, whether it's Mullins or whether it's Bruce, or every one of the cases in their line deals with interests that did not violate the original common law rule against perpetuities. Interests where the people were ascertained and where it would have vested and was tied to a life ending plus 21 years. In other words, a typical fact pattern might be, I give to my sister, but if she dies without kids, it goes to my brother. All those people were known, and what those courts in each of those cases said is if they all get around the table and everybody's present, and that's going to be tied to a life in being, and it's going to vest within a life in being plus 21 years, and there's no confusion as to the individual or when it's going to vest, then it can be released. The second it goes outside of that bound and becomes remote, it can't be released. And Yarborough is very clear about that. And we cited several quotes in our brief where we quoted Yarborough. This is a quote from Yarborough. No conveyance or mode of alienation can pass an absolute title because it is wholly uncertain in whom the estate will vest, on the happening of the event, or breach of the condition upon which the ulterior gift is to take effect. Yarborough talks specifically about the application of the common law rule against perpetuities. It distinguishes from a possibility of reverter, which is transferable, and it even draws a comparison. Yarborough does this great comparison where it says, here's the difference between a reverter and an executory interest. The possibility of reverter, being a vested interest in real property, is capable at all times of being released to the person holding the estate on condition. It is otherwise with gifts or grants of estates in fee, with limitations over upon a condition or event of an uncertain or indeterminate nature. The limitation over being executory and depending upon a condition or an event which may never happen passes no vested interest or estate. It is impossible to ascertain in whom the ultimate right to the estate may vest or whether it will ever vest at all. This interest in 1925, no one knew if it would vest in 1926 or 1976 or 2020 or 1,000 years from now. It was an indeterminate amount of time, and it was also not an ascertainable person. It was the estate. And the case law is clear. We've cited this throughout our brief. Most of it's out-of-state case law on this particular issue, but I don't think it's in dispute. that when the rule against perpetuities talks about being tied to a life in being, it's talking about a human life. It's not talking about an LLC or a corporation or an entity. And so what NCC is trying to argue is that, well, an estate is ascertainable, and because it's ascertainable, this would have been releasable. But again, I come right back to that Whitaker case where all four parties were ascertainable and known, but yet the court said that's not transferable, it's not leasable, you can't do anything with it because it's void. So in essence, this case would have been very different if analyzed under the rule against perpetuities. But in 1994, the uniform statutory rule against perpetuities comes out, which says non-donative transfers don't apply, and we look backwards. So what Chancellor Martin correctly did is, just like the Court of Appeals in White versus Hayes, which she cited in her opinion, she looked backward. And she said this analysis might have been different if it had happened before the new rule. But under the current rule, looking back at this 1925 interest, which is now being challenged for the first time, this is the first time this has come into court. So the new rule applies, because the new rule says it's prospective and retrospective. And using that new rule, that interest stands, and it cannot be alienated, sold, transferred, conveyed in any way, because it's an unvested executory interest. It's not a non-remote contingent remainder where we know who's going to take or when they're going to take. And as a matter of fact, we don't know when it's going to vest. In all those cases, in Bruce, Mullins, it's very easy to know when it's going to vest because they're all tied to a life and being. So at some time within that life, we're going to know, did that person die without kids? Did that person die without ever getting their degree from the university? Did that person die without whatever the immediate condition is? Here, it's unknown whether this condition will ever be breached. And that's why it's in the Yarborough camp and not the Bruce camp. And we believe the Chancellor correctly addressed that, and we would ask that she be affirmed. We also addressed, I'm running out of time, so I'll jump to this, but I'm happy to take any questions. We also addressed this issue of the 2018 quitclaim deed.
Before you get to that, Mr. Belcher, let me ask you a question, and this is something your opposing counsel mentioned earlier. Well, first of all, let me ask you, you argue that if we're looking at the term, the estate of A.M. Burton, I think in your brief you argue that does not mean the same thing that opposing counsel says it means. Opposing counsel argues that it means the estate, as in the property of, and cites what they believe to be persuasive authority in the King case from Kentucky, the Cannon case from South Carolina, I believe it was. What's your answer to that?
We respectfully disagree with that, and we think, for instance, the Cannon case, in that case, the condition was triggered while the person was still alive. And so the court was looking at a situation where it almost was as if it was a reverter. This is very different. The condition was never met while A.M. Burton was still alive. In Tennessee, those are out-of-state cases. Tennessee has a statute that says real property doesn't vest in the estate. It says real property vests in the heirs or beneficiaries, and there's a vesting statute we've cited in our brief. The estate is only a placeholder. And so our argument to the trial court, and the trial court held, the estate is the proper party to enforce this limitation. The estate's the proper party to come to court. But ultimately, one day, if this vests, if the condition's met, the estate won't be the ultimate owner of this. It would pass through to, and that's a question for another day, who those individuals would be. That would depend in part on the date of the condition being met.
Well, let me ask you what your answer would be to this, Mr. Belcher. Let's say that, just as your opposing counsel had mentioned earlier, let's say that the church in some way violated this restriction in 1943. Then what?
If the church had violated the restriction in 1943, respectfully, we believe that would have wound up in court, and the court would have applied the rule against perpetuities and may very well have disallowed that limitation. That didn't happen. That's an important thing that didn't happen. But that's one outcome that could have happened. The court could have said, this interest does not vest in a life and being plus 21 years, therefore we're going to follow the common law rule against perpetuities. Or the court may have looked at it and said, under these circumstances, with A.M. Burton being alive, perhaps they would treat it as if A.M. Burton and the estate were synonymous. We don't know. I mean, that'd be me speculating. But the important thing is, A.M. Burton was not alive, and that's not in dispute. At the time, we don't even know yet if the condition's been triggered. That part of the case has not been addressed yet. But we do know that A.M. Burton died long before, and I believe the record has been clear that the property was used as a Church of Christ up until at least sometime in 2017, I believe the papers say, and so this dispute arose many, many years after his death. But had he died, had this issue been raised to a court before 1994, certainly, then one possible scenario is that the court would have looked at the common law rule against perpetuities and says, does this conveyance meet it? Is it subject to a life in being plus 21 years? And maybe the court would have said, no, this might not take effect for 10,000 years. But under the new statute that we're obligated to follow now, which looks backwards, it's okay if it's an undonative transfer, if it might not vest for 10,000 years. That's what the law tells us now, and that's what the Court of Appeals said in the White case, that we look backwards and apply the new law. And so I hope that answers the court's question, but
It does. Thank you.
That's how we believe that would have been handled.
Thank you.
I see I'm in the red. I see it looks like I've gone over, so I'm happy to answer questions, but otherwise I'll put my pen down.
You've used your time. Question?
No.
Oh, you've used your time.
Thank you.
May I proceed?
Certainly.
I'm not going to have time to address everything that Mr. Belcher said, but I will tell the court it was addressed in our reply brief. These are the issues that were raised in the response, and we have addressed those, but I am going to try to hit a couple of those now. The arguments regarding Yarbrough v. Yarbrough and the rule against perpetuities, this has always been a little puzzling to us, and I think it's important to note that the Burton appellees are asking the court to affirm the trial court's decision, but on grounds that the trial court rejected. The trial court did not agree with Mr. Belcher on these issues regarding Yarbrough v. Yarbrough and the separate lines of cases and one applying to ours and not the others. Well, in a way, one applies to us and not the other, but it's flipped from what Mr. Belcher was saying a moment ago. The bottom line is the Yarbrough line of cases are fantastic cases for understanding the different types of future interests. That case does a great job of laying out the difference between a contingent remainder, a reverter, a right of reversion, and an executory interest that's off to a third party. And the bottom line is that case was not looking at the issue of alienability, it was looking at the issue of remoteness and understanding which ones of these future interests violate the rule against perpetuities and which ones do not. There is a provision that it's been cited multiple times by the Burton appellees in briefs, and there's always a section of that quote that's left out, and I won't use our time to go over that, but I will ask the court to look at pages, I believe it's pages 9 through 12 of our reply, where we go through all of these issues and explain why, frankly, it just doesn't comport with Chancellor Martin's order or Tennessee law generally in looking at whether an executory interest is alienable. It's a totally separate question from remoteness. Once the rule against, we agree that the TUSRAP is retrospective. If it weren't, we wouldn't be standing before the court right now because the interest would be gone and there would be nothing for the Burton appellees to claim under. But with the TUSRAP excluding non-donative transfers, remoteness just really isn't an issue here anymore. And executory interests are on the same footing as contingent remainders. We've cited several cases that make this point very clear. And so the line of cases, just as Chancellor Martin said in her opinion, that apply here are Bruce v. Goldberg, Mullins v. Mullins, Frank v. Frank, Towns v. Walters, I believe that one's out of Georgia. And these are the cases that explain that contingent remainders and executory interests, which are on the same footing, are alienable so long as the taker is ascertained. And the only part we challenge with Chancellor Martin's order is where she determined, without a lot of analysis, frankly, that the estate of A.M. Burton is not an ascertained taker. And so the reason you see this sort of separate line of cases is back in the time when these cases, these older cases were coming out, the rule against perpetuities was there. And executory interests were almost always going to be eliminated, and the courts would have no reason to get to the question of alienability because the interests were dead on arrival. They were void. Where you see the analysis instead is in the context of contingent remainders, because as Mr. Belcher said, they don't have this issue with remoteness, so they don't get stuck on the rule against perpetuities before these other questions could get answered. And we ask that this court affirm Chancellor Martin's analysis, where the Bruce, Mullins, Frank, Towns line of cases are the ones that address alienability and apply here. And they all stand for the position that as long as you have an ascertained taker, there's no contingency as to who would take, and I haven't heard any dispute. It's the estate of A.M. Burton. The only question is, what does that mean? And so we'd ask that. There was another point I wanted to address, but I'm out of time. May I briefly conclude?
Sure.
We stand on our briefs and our argument, and we just ask this court to reverse the challenged portion of the trial court's March 23rd order and direct the trial court to enter an order quieting title and declaring the parties' rights as requested in NCC's briefs, and further instructing the trial court as requested in NCC's briefs. Thank you, Your Honors.
Thank you. Thank you, counsel. We appreciate the argument, the briefing. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible time. Thank you. You may be excused.